10, 9, 8, 7, 6, 5, 4, 3, 2, 1, 0.
Hi, Assalamualaikum everyone. Today our group will be present on Industrial Court Case Award entitled Deadlock Interactive Agreement between Kesatuan Sekerja Industri Elektronik Malaysia Utara Semenanjung Malaysia and Panasonic Automotive System Malaysia Sdn Bhd. Industrial court case is regarding a trade dispute between Kesatuan Sekerja Industri Elektronik Wilayah Utara Semenanjung Malaysia as a union and Panasonic Automotive System Malaysia Sdn Bhd as a respondent. The trade dispute arises between Kesatuan Sekerja Industri Elektronik Wilayah Utara Semenanjung Malaysia and the Panasonic Automotive System Malaysia Sdn Bhd on the term of first collective agreement for the period commencing on 1st January 2018 and ending on 31st December 2020. The union obtained its recognition from the respondent, which is the company, on 2017 and proceed to negotiate its first collective agreement with the respondent. The union served its proposal to the respondent to negotiate on the term and condition of employment on 3rd January 2018 and commenced several negotiations, but it came to a deadlock. Hence, the matter was referred to the court for an award.
50C article in the said collective agreement. Of 50C articles, 21 articles were subsequently agreed upon, whilst 3 articles were abandoned by the union, leaving a total of 20 articles to be adjusted. The agreed articles form part of this award and are assigned hereto as Annexure A. The dispute articles are as follows. On Article 1 discuss about parties to the agreement. In this agreement, parties that involve into an agreement which are between Panasonic Automotive System Malaysia Sdn Bhd, hereafter referred to as the company, and Kesatuan Sekerja Industri Elektronik Wilayah Utara Semenanjung Malaysia, hereafter referred to as the union. According to Industrial Relation Act 1967, collective agreement means an agreement in writing concluded between an employer or a trade union of employers on the one hand and a trade union of workmen on the other, relating to the terms and conditions of employment and work of workmen or concerning relation between such parties. Next, on Article 4 states about effective date and duration of agreement. Under Section 14, Subsection 2 of Trade Unions Act 1967 states that a collective agreement shall set out of the term of the agreement and shall, where appropriate, specify the period it shall continue in force, which shall not be less than 3 years from the day of commencement of the agreement. An agreement between the company and the union shall take effect from 1st January 2018 and shall remain in force and begin on the company and the union for a period of 3 years until 31st December 2020. Renegotiation of the agreement was discussed on Article 6. Clause which states that any current agreement will remain in force until a new agreement is signed. On the agreement between Panasonic Automotive System Malaysia Sdn Bhd and Kesatuan Sekerja Industri Elektronik Wilayah Utara Semenanjung Malaysia, either party may serve on the other's 3 months writer notice to renegotiate on new terms and conditions of employment and other related matters, but nothing shall be served early 30 September 2020, and also submit proposals on terms and conditions of employment for renegotiation. The provision of the current terms and conditions of employment shall prevail until specified by new terms concluded between the parties or by an award of industrial costs. Under Section 13, Subsection 1 of Industrial Relations Act 1967 mentions that where a trade union of employers has been got recognition by an employer, the trade union of employers, which are the trade union of workmen, may invite the employer or trade union of employers to commence collective bargaining. Furthermore, recognition of the union on Article 10 also discussed in the agreement. Recognition by the individual employer is important where the union is set as the rightful representative of his workers and has the right to speak on their behalf. Recognition is the starting point for collective bargaining. No recognition means the union cannot commence collective bargaining as well as to enhance harmonious industrial relations. The application for registration must be signed by at least 7 members, which is the minimum member needed to form a union. In agreement between Panasonic Automotive System Malaysia Sdn Bhd and Kesatuan Sekerja Industri Elektronik Raya Utara Sembilan Malaysia, the company shall not restrain those covered by this agreement from joining the union. The company recognized the right of the union to make representations with respect to the company's action which are contrary to or tend to diminish the value of the provision of this agreement and to bargain collectively. The chain-off process allows union subscription to be paid by an employer direct to a union on behalf of its employees via salary deduction. Based on the agreement, the company agrees to deduct union monthly subscription from the wages of each union member who has authorized the company to do so and to remit such subscription to the union monthly. The company shall stop deducting the union subscription of its members upon being notified by the union to do so, and the company shall continue to make such deduction so long as the authorization remains in force. On Article 70 discussed about paid leave for the union activities, the company shall grant members of the union paid leave to attend trade union courses, seminars, or conferences. Besides that, the company shall claim from Human Resource Development Fund (HRDF) and reimburse to the union the expenses on occasion where training is conducted by the union for the members from the company. Appointment and probationary period was discussed on Article 19. The employee will be on 3 months probationary period from the day of her employment. The company may, at its consideration, to extend the probationary period in which the employee will be informed in writing. Based on agreement between Panasonic Automotive System Malaysia Sdn Bhd and Kesatuan Sekerja Industri Elektronik Wilayah Utara Semenanjung Malaysia, employees who are engaged or permanent employment shall on appointment serve a probationary period of not more than 3 months, which are extended with just cause and excused by another 3 months. The company will inform to the government for the extension of the probationary period in writing before the completion of the initial 3 months period.
The union also demands the termination notice in this case. According to Agreement 21 in collective agreements, a notice may be received by whether party in writing or payable in view of 24 hours of workman's probation notifications of termination at any time during the probationary periods. However, for the verified notice of terminations or dismissal by whether the company or the employees, a 1 week's written notice of payment shall be made in view of such notice. In relation to the Section 5, Section 2 of the Employment Act 1955, for the both employer and employees, the notification shall be not be less than 4 weeks if the employees have been employed in that capacity for less than 2 years on the date on which the contract is made. If the employee has employed in that capacity for 2 and longer years but not less than 5 years on the date 6 years notice have been received, and if so employed for 5 years or more than the date, a notice shall be released for 8 weeks. The unions also demands overtime payments on the basis of these collective agreements. In addition, the company shall grant an additional 15 minutes tea breaks for the employees who are required to work overtime for at least 2 hours in excess of normal working hours. Besides, the total overtime performed by any employees shall be not exceed 104 hours per month. This statement further outlines the law and regulation in compliance with Section 60A of the Employment Act 1955. In addition, any employer who permit an employee to work longer than the law permits commits an offence to which she would be tried was indicated in the regulations. Regulation further clarified that employers can apply to the employees to work overtimes, and that the overtime rate of the pay is to be paid if the employees choose to carry out the extra work. Most employees have the right to decline an overtime applications unless they consent to work overtime on request through their employees' contracts. Section 16D of the Employment Act 1952, the Central of the Government of Malaysia or the Government of the State of the Selangor shall be grant employees paid holiday in the entire public holiday gazettes. In addition, any employer allowed to work at public holiday will be paid 2 days wages at the daily pay rate in addition to the usual salary on the holiday, regardless of the whether the working time is less than the normal hours. Under the Section 60E of the Employment Act 1955, each employer shall have the right to annual leave after the full year of the service has passed. However, the first year of the service, there are several employers that make their employees annual leave. The period of the employees' annual leave depends on their length of the service. Unfortunately, the union state that the worker of the fewer than 2 years service are entitled to 14 days a year under the collective agreements. Those with the career of 2 to 5 years are entitled to 6 days a year, and those with a seniority of more than 5 years are right to an annual leave of the 18 days a year. Regarding to the collective agreements, the decision of the courts for the Article 31 is not granted. The existing provision of the Employment Act 1955 must have to maintain and come on the unions or workmen. The workmen also claims that the company shall grant 90 days paid maternity leave to each feminines. The maternity leave may commence only after the 22nd week of the pregnancy, and the leave of the absent from the work due to any illness or miscarriage during the first 20 to 22nd week shall be considered as the normal sick leave.
Next, we proceed to Article 33. Article 33 from the dispute article is regarding the issue of retirement benefits. The union requests to the company for providing the retirement benefit to its employees accordance with the conditions stipulated, which the contribution is to the company's statutory EPF contribution as specified under EPF Act 1951. Union asks the company for the payments additional sum of 1 month multiplied by the number of years of service since the employees joined the company until 31st December 2017. The union submit the proposal and claims that it is reasonable for the purpose to give warranty to the employees of the benefits in a long time of period that lead to low turnover rate. However, the respondent, which is the company, resists that the retirement benefits are considered as an unrestricted incentive to be married beside by the company. For the court decision, the Article 33 is not granted by the court decision because the issue of retirement benefit should be left to the discretion of the employers. 34 is about retrenchment and retrenchment benefit that the union requests to the company. The union gives the condition where, in the case of where the employee's service is being terminated due to the redundancy, the employees must be given 2 months written notice of termination or 2 months wages in lieu and eligible for retrenchment benefit of 2 months last run wages for each complete years of the service. The respondent, which is the company, view the union's proposal related to the part of the demand for 2 months wages for each complete year as an excessive and not supported by any valid reason. For this section, the court decided that only several items of Article 34 of the proposed collective agreement is granted. The parties should revise the retrenchment benefit accordingly to be consistent with the provision of the termination and layoff benefit regulations 1980. Since this is the first collective agreement between the parties, this article can be improved over the times. For Article 54 regarding the bonus, the union acknowledged that bonus is an incentive given by the employer to its employees. However, the respondent is in financial position to give contractual bonus which is tied to performance. The respondent currently gives a review bonus as opposed to a contractual bonus. The union proposed a 1 month contractual bonus. Okay, in this case, the respondent argued that bonus is gratuitous payment and is related to profit and productivity. Finally, the court have decided that this article is not granted as it is the employer's prerogative and relate to profitability and productivity. The current global crisis does not bode well for the bonus payment. In this court case, as the final decision, taking an evidence as a whole and mindful of Section 33, Subsection 5 of Industrial Relations Act 1967, which requires this court to act according to the equity and good conscience of the case without regard to legal forms. This court finds that the party has either agreed of the sum of the article while union had abandoned some of the articles. In handling down this award, the court had taken into consideration the interest of its members of the union as well as the financial implication of the respondent, especially in this fragile economic climate caused by the pandemic COVID-19.
As a conclusion, the collective agreements can be beneficial to both employees and employer. The party may be agree on mutually beneficial terms in the collective agreements. The employers determines better workings and social protection rule which motivates the employees to initiate or continue the labor's legal relationship with the employer. Will the employer improve the quality of the work competitiveness and work result due to using its most valuable resource plus motivate and certified labor force? Okay, that's all for us. Thank you.